Welcome back. The Chief Justice of Nigeria, Justice Walter Onoge, has rolled out some new rules for judges. He did this last week Tuesday at an event organized by Presidential Advisory Committee Against Corruption, PACAC, in Abuja. We have details up next.
Today.
The event, a rule of law and anti-corruption program, is an initiative of the Presidential Advisory Committee Against Corruption, PACAC. It attracted stakeholders from the judiciary, the legislature and the executive. The chairman of PACAC, Professor Ise Sage, sets the tone for the meeting with these words.
Currently, there's too much lip service in the fight against corruption. At times, people enjoying public trust over our public assets help themselves to such assets that are under their control and then go on to condemn corruption in other arms of government, totally oblivious that they themselves are the guiltiest of this offense. For example, I think the legislature should fight budget padding, unjust remuneration, and they should pass all pending anti-corruption bills. Judges must have zero tolerance to lawyers who approach them to compromise them. Rather, they should expose them, such lawyers, and have them struck off the roll. All judges should be prepared to bring to justice any of their own colleagues who accept or demand bribes. These are the ones who rubbish the image of the judiciary and certainly not legitimate critics of such gross misconduct.
The Chief Justice of Nigeria, Justice Walter Onoge, is represented here by the President of the Court of Appeal, Justice Zainab Bukachua. She tells the gathering about some of the reforms proposed by CJN for the judicial sector.
Clearly, any unnecessary delay of justice is equally an act of corruption. Therefore, to enhance speedy dispensation of justice, we are ensuring that the rules of court procedure must contain a provision for the award of punitive costs by the court for frivolous litigation or delays which are caused by counsel. In the same vein, I am reviving and strengthening the Inspectorate Division to go around the country and ensure that, in line with public service rules, all judicial officers go to work and sit in their courts from Monday to Friday from 9 a.m. to at least 4 p.m. And in line with the NJC's revised Code of Conduct for judicial officers, I've directed that travels outside Nigeria should be with the permission of the Honorable Chief Justice of Nigeria after an application would have been made. For enhanced performance, all judges of lower courts in the country had been directed to submit returns of cases quarterly to the Federal Judicial Service Commission, FJSC, for assessment, as it is done by the National Judicial Council in respect of serving judicial officers of superior courts of records. In the area of appointment, all judges of lower courts and other public officers, such as chief registrars and secretaries, among others, are henceforth required to write examinations and be interviewed, in addition to the submission of copies of their judgments to the NJC when they are to be considered for judicial appointment. For members of the bar who seek judicial appointments, the President of the Nigerian Bar Association will, in addition to the requirements of the NJC guidelines on appointment of judicial officers, assist the NJC with a separate assessment report on all MBA candidates being considered for judicial appointment. In the area of discipline, members appointed to serve in any fact-finding committee will henceforth be expected to complete their investigation and submit their reports within 21 days. And considering the increasing number of petitions written against judicial officers, will constitute more committees to investigate the allegation therein.
The CJN also says he has asked all heads of court to designate some courts in their jurisdictions as special courts to handle corruption cases, while 20% of judiciary budget is to be devoted to the Justice Suleiman Galadima-led Corruption and Financial Crimes Cases Trial Monitoring Committee.
And from there, let's check out some of the top trending stories from the courtrooms.
We begin with the report that the trial of the Senate President, Dr. Bukola Saraki, has been adjourned till March the 8th, 2018 for parties to adopt their final briefs. The chairman of the Code of Conduct Tribunal, Mr. Danladi Umar, adjourned following claims by the lead defense counsel, Mr. Kanu Agabi, that he was served with the brief of the prosecution on Monday, February the 26th, 2018. Mr. Agabi had pleaded with the tribunal to adjourn the matter to enable him study and respond to the documents. The prosecutor, Mr. Rotimi Jacobs, admitted that his brief was served late, but blamed the defense for the lateness on the grounds that their brief of arguments was served 7 days after it was ordered by the tribunal. Having listened to both sides, the tribunal chairman adjourned the matter to March the 8th for the adoption of final written address. Mr. Danladi also said that after the formal adoption of the written address, the tribunal will take a date for judgment in the suit, which commenced since 2015. Staying in Abuja, the Supreme Court has dismissed an appeal filed by the immediate past National Security Advisor, retired Colonel Sambo Dasuki, seeking to compel the Department of State Services to release him from detention. Colonel Dasuki had specifically challenged the validity of his trial while being detained by the DSS since December 2015. In June 2016, the Court of Appeal had dismissed Colonel Dasuki's plea that his trial before Justice Hossein Baba of the FCT High Court Abuja should be suspended until the DSS obeys a court order which had granted him bail. Dissatisfied with that verdict, the former NSA had approached the Supreme Court for redress, but in a unanimous judgment read last Friday by Justice Ejembi Eko, the court dismissed his appeal for lack of merit. The Supreme Court then remitted the case back to Justice Baba Yusuf for an accelerated hearing of the case. And in Lagos, the Federal High Court has ordered the final forfeiture to the federal government of 2 penthouses valued at $4.76 million, allegedly linked to the former Minister of Petroleum, Daisani Alison Madueke. Justice Mojisola Olatoregun specifically ordered that the 2 properties, both located in Ikoyi, Lagos, shall be forfeited to the federal government. The judge had on December the 5th, 2017, ordered the temporary forfeiture of the properties after hearing an ex parte application filed by the Economic and Financial Crimes Commission. With no objections to the application, Justice Olatoregun granted the order for a final forfeiture of the properties. And in the trial of a former Minister of Aviation, Femi Fani-Kaude, and 3 others for allegedly laundering 4.9 billion naira, a 3rd prosecution witness has testified. The witness, Shilis Ghana, a branch manager with Zenith Bank, narrated how Mr. Femi Fani-Kaude opened an account with the bank in January 2015 during the build-up to the general elections. She also took the court through several inflows and outflows which occurred on the account within January and March 2015. Under cross-examination by one of the defense lawyers, Ferdinand Orbe, the witness told the court that one of the documents submitted by the bank to the EFCC during the course of the agency's investigations was found to have been doctored by certain officials in her bank. She also testified that though there were certain withdrawals from the accounts which exceeded the legal withdrawal limit of 5 million naira for individuals, she could not confirm that Fani-Kaude personally received the monies.
And with that, we come to the end of this week's episode of Law Weekly. Do feel free to send in your comments via any of our social media handles. You can also watch this episode of the program or past ones on our YouTube channel. I am Shola Sheyeli. Thank you for watching.